In today's topic, we are going to discuss difference between infringement of trademark and passing off action. Infringement of trademark, it is a remedy which is available only in case your trademark is a registered one. That means as a registered proprietor, you have a certain right, and that right is to bring infringement proceedings against the person who is unlawfully or unauthorizedly using your trademark. But passing off can be used not only when your mark is registered but also in case of an unregistered trademark. So what remedy do the people who have not registered their trademark? They have got the remedy of passing off. It is important to note that infringement is a statutory remedy. Statutory remedy means this right is expressly provided to you under the Trademarks Act 1999. But passing off is a common law remedy. As a matter of right, आप कोर्ट से जाके क्लेम नहीं कर सकते हैं कि मेरा मार्क अनरजिस्टर्ड था लेकिन फिर भी इसको किसी ने डिसेप्टिवली कॉपी किया है, इसको चुराया है, तो मुझे रेमेडी चाहिए. सो इट इज़ अ कॉमन लॉ रेमेडी विच इज़ अप टू द डिस्क्रिशन ऑफ द कोर्ट, विच मे और मे नॉट बी अवेलेबल टू यू. Second thing is that passing off is similar to trademark, but it applies to protect unregistered rights associated with a particular business, goods and services. Passing off actions can be brought in a wide range of situations, including to protect business names and features of get-up or trade dress. That means आपको दिखाना ज़रूरी नहीं है कि उस person ने आपका trademark use किया है. You just need to prove before the court that your goodwill has been stolen by that person. Your trade dress or your get-up, the get-up of your product has been stolen. In infringement, actual use of trademark is necessary, but in passing off, you just have to show that that person is stealing my goodwill, my trade dress up, my get-up of my product. That's all you need to show. And these things are actually difficult to prove. Infringement is very easy to prove before a court because once you have registered your trademark, it becomes a prima facie evidence of the fact that you have this mark in your name. But in passing off, it's very difficult to prove that you have the right upon this product to make this product look like this, to that you have the rights on this. So that's why passing off is not a statutory remedy. It is up to the court. The court will see whether to give this right to the claimant or not. So principle behind the passing off is that a man cannot sell his own goods under the pretension that they are goods of another man. Basically what the word passing off means. The word passing off means passing off the goods, passing off your goods as goods of another person. किसी person के brand को, उसकी goodwill को आप अपने goods के ऊपर लगा के या अपने goods को वैसा show करके market में pass off कर रहे हैं. Passing off action के बारे में एक provision दी हुई है section 27 of the Trademarks Act में. Expressly ये right नहीं दिया है, they have stated it in negative terms. Coming to section 27, please read the bare language of section 27. No person shall be entitled to institute any proceedings to prevent or to recover damages for infringement of unregistered trademark. First of all, they are clearly stating that if your trademark is unregistered, then you shall not be entitled to any remedies by the way of recovering damages for infringement. Then come to the second point. What does this say? Nothing in this act shall be deemed to affect the right of action against any person for passing off the goods or services as goods of another person. But if we find one person as passing off his goods and services like the goods and services of another person, वो अपने goods को किसी दूसरे के goods के जैसा बना के बेच रहा है market में, then that person, even if his mark is unregistered, has the right against another person that this person is selling of my goods or services and is passing off goods and services of mine as goods or services of himself. Essential features of passing off. Basic object or the object of the remedy of passing off is to protect not the trademark, because trademark is unregistered. It is to protect the goodwill or reputation of the business from encroachment by dishonest competition. For example, take some hypothetical situation that you have a restaurant running for more than 50 years. That means your generations are running that restaurant. But you are not so much aware that you have not registered that name. But what some other person does is he opens a restaurant in the same name and very immediately, as soon as possible as he gets, he registers it. Now, name is yours for more than 50 years. But what he has done? He is registering it in his own name. So in that case, you will have this common law remedy of passing off as a matter of goodwill. As a matter of goodwill, you can show to the court that yes, this restaurant is in our name for so many years and we have got this remedy against this person, and you can take the remedy of injunction. So in an action based on passing off, the plaintiff must show that there is a misrepresentation made by the defendant in the course of trade to prospective customers or ultimate customers of goods or services supplied by him. I am actually supplying those goods or services, but the defendant is misrepresenting to the prospective consumers or customers that these goods or services do not belong to me, but these goods or services belong to him. Second, this misrepresentation is with what intention? It is with the intention to injure the business or goodwill of the plaintiff, and the plaintiff has suffered damage. Third thing is very, very important. Then while differentiating between infringement and passing off. In infringement, merely the use of trademark amounts to infringement, but in goodwill in passing off, you have to show that the plaintiff has suffered a damage to the business, to his reputation, to his goodwill. Unless and until you prove this damage, the court will not give you the remedy. In trademark infringement, no damage needs to be proved, but in passing off, the damage or the injury to your reputation because of using of that mark by another person, it needs to be proved. Various modes by which passing off can be done. First of all, directly falsely representing. Second, adopting a trademark which is same or a colorable imitation of your rival. Third, by adoption of essential features. Uske substantial features copy kar lena. Adoption of essential parts or essential features of your rival's trade name. Copying the get-up or color scheme. For example, if somebody copies the color scheme of Domino's, which is blue and white, actually Domino's is a registered trademark. In case it is unregistered, then it will be a case of passing off. Adopting the design or shape of goods. Next, I am going to tell you the difference between infringement and passing off. First difference we have already done. Infringement is a statutory remedy which is expressly available to you under the Trademarks Act. Passing off is not a statutory remedy. Nothing in clear words in the Trademark Act is written that you as a proprietor of your business have got the remedy. But it only in negative terms they are stating that nothing in this act shall deem to affect the right. That means कि अगर आपको unregistered में कोई remedy available नहीं है तो हम ये नहीं कहेंगे कि आपको कॉमन लॉ में भी रेमेडी अवेलेबल नहीं होगी. सो नथिंग इन दिस एक्ट शैल डीम टू अफेक्ट द राइट ऑफ एक्शन अगेंस्ट एनी पर्सन फॉर पासिंग ऑफ द गुड्स और सर्विसेज एज गुड्स ऑफ अनदर पर्सन. Second difference. In infringement, you require registration of your trademark, but in passing off, registration of trademark is not a prerequisite. That means it is not essential. Third thing, plaintiff is only required to establish in infringement that infringing mark is deceptively similar to the registered mark. No further proof is required. There is a presumption of confusion in infringement, but in passing off, you are not only required to establish deceptive similarity, but also required to prove deception or confusion among the public. That means the burden of proof in passing off is upon the plaintiff, but the burden of proof, there is no such burden in infringement. There is a presumption that if your trademark is registered and some other person is using that similar trademark, then the people are deemed to be, they are presumed to be confused. Fourth difference, the prosecution under criminal law is very easy because expressly the remedies are given under the Trademark Act for infringement. But prosecution under criminal law in case of passing off is very difficult because there are very less provisions under IPC or maybe under 1 or 2 laws, and there are not much remedies in case you want to file a criminal case. Next thing is that benefit of instituting a suit under Trademark Act in case of infringement is available when the registered proprietor can institute the suit. It is a provision that infringement के केस में रजिस्टर्ड प्रोप्राइटर सूट वहाँ पे इंस्टीट्यूट कर सकता है जहाँ पे प्रोप्राइटर रहता है. He can institute the suit where he actually and voluntarily resides or carries on business or personally works for gain. But such benefit is not available in case of passing off, because in passing off there is nothing given in the Trademarks Act, and the normal rule of CPC relating to the place of suing, place of institution of suits will apply, where in CPC it is expressly written where the defendant resides or carries on business or where the cause of action has arisen, the case will be instituted in that place. So this benefit is also not available in case of passing off. Last difference is that in case of infringement, it is sufficient to prove that this person, this defendant has used my trademark. So mere use amounts to infringement. But in case of passing off, mere use does not amount to passing off. You have to prove further that using of my business name, my goodwill, my brand name has led to some kind of pecuniary injury to me. It has led to the damage of my reputation. So in any way you have to show that injury has been caused to me. This thing is not necessary to show in case of infringement. Okay. Some cases I am going to discuss with you of passing off. The first case is Dhariwal Industries versus Messrs. MSS Food Products. In this case, the Supreme Court upheld the claim of respondent to use a trademark Malik Chand for Pan Masala on the basis of prior user and restrained the appellant from using the trademark Manik Chand, though the Pan Masala Malik Chand was not registered and the Pan Masala Manik Chand was registered, but still the Supreme Court upheld in favor of Malik Chand because they were using this name for so many years. That means since 1959 they were using this mark. Since 1959, whereas the defendant they had started selling this product very recently in 1988 only. That is why the trademark of Malik Chand, though it was unregistered, it was given preference. Next case is Midas Hygiene Industries versus Sudhir Bhatia. The Supreme Court allowed the appeal and found that the use of magic Lakshman Rekha by the defendant was an attempt to pass off the goods by using the goodwill of plaintiff trademark Lakshman Rekha. There was one product named Lakshman Rekha which is used for cockroaches and lizards, and what they did, they never got that trademark registered. Now some other company, it made the same kind of product named as Magic Lakshman Rekha. So the court held that the mark Lakshman Rekha will be given preference, though it is not even registered. The court held that mere delay in instituting proceedings is no ground to refuse injunction. One case of cyber squatting is one more there, that is relating to Yahoo Inclusive versus Akash Arora and others. In this case, the defendant used Yahoo India, and this Yahoo India domain name was deceptively similar to the plaintiff's domain name Yahoo. So the defendant was restrained from using Yahoo India. In Rediff Communications Limited versus Cybertooth, the court restrained the defendant from using the domain name Radiff, which was sought to be passed off as trademark Rediff of the plaintiff. Also in case of domain names, you don't have any remedy in Trademarks Act of infringement, because these are not registered as trademarks, the website names. The only remedy you have in these cases is of